So today we're talking, general leave entitlements as a fairly basic starting point. In terms of general award conditions, there are oftentimes myths and misconceptions in just even what the basic leave entitlements are and how they operate and how they work. So we'll cover off those. We'll also deal with some of the periphery issues, such as, or bugbears even, excessive annual leave balances, when workers come to us requesting cashing out of annual leave, those employees who regularly take sick leave, and some issues around how leave accrues and when it starts and when it stops, and things around directions to take leave, where perhaps just excessive leave balances, but also when it's allowable to direct workers to take that leave. We'll be focusing mainly on the electrical award provisions. We will also refer to the clerk's private sector. A lot of these general leave entitlement conditions exist in the legislation, but where the award differs is in things like the rules around directions to take leave, cashing out provisions. Those become award specific or instrument specific, such as your enterprise agreements. So this slide, I guess, just covers off the main entitlements, ones we should be aware of, be accruing for, have an understanding of for a full-time employee. Now, a part-time employee, they still get 4 weeks of annual leave, but the 4 weeks is based on their pro rata entitlement. So if they do 24 hours a week, they will get 4 weeks based on 24 hours a week. Same with the 10 days personal leave or 2 weeks of personal leave. It's based on their week, what their working week is. One of the ones that probably catches most employers out is compassionate leave. That's simply per occasion, and an occasion can be for the serious injury or illness or death of a family member. It doesn't come from any leave balance, leave accrual. We will cover off compassionate leave a little bit more, but I just wanted to highlight that one. Parental leave, the unpaid component of 12 months, is probably something that people would understand just from being around the traps of being employers for a period of time. The part that may be surprising to some is to see that there is a possibility for an additional 12 months, and that additional 12 months is only at request of the worker. It's exceedingly rare. I mean, it's been in place since the Fair Work Act was enacted in 2009, and I've been, doing this for a long time. I've not really seen more than perhaps one of those that I'm aware of where someone's requested an additional 12 months, because people need to get paid, and 24 months off without pay is a long, long time. Community service leave, that's where we're talking about voluntary emergency services and jury duty. Long service leave is still dealt with in state-based legislation, and we'll cover that off as well. Family and domestic violence leave, the unpaid, is a new provision, which is both in the award and the legislation, but we'll cover off that as well. That'll be probably new to everyone. Just give me... Thanks. So if you have any questions as we go through, please use the chat facility on the left-hand side. Some of this stuff is going to, as I say, is fairly basic to begin with, but I'd like to start at the beginning so that we understand where we're going to when we get to the more complicated areas of award interpretation and or the legislation. The annual leave or general leave entitlements is it's paid at the current rate of pay. That's the normal rate of pay. Sometimes we can get some difficulties where someone's perhaps receiving well, not some difficulties, but some unintended consequences where someone's receiving a higher rate of pay as perhaps a leading hand or something like that, which is an all-purpose allowance, which they receive right before going on annual leave. They would continue to receive that rate, including perhaps the leading hand allowance, whilst they're on leave. The other part that becomes a bugbear for a lot of members is if an apprentice has been with you for their entire duration and they perhaps carry a 2-week balance of annual leave from each year, we don't backtrack and pay it at the apprentice rate of pay for the relevant period. We pay it at their current rate of pay. So if someone rolled over from apprentice to tradesman with, say, 4-week balance, they would be entitled to be paid any annual leave that they took from that time at their new tradesman rate of pay, whatever that might be. If you're just using the award minimum or some higher rate, we need to pay it at that rate. While we're on the topic, and it's a common misconception and not really, I guess, the point, but we don't, at the point of this presentation, but I'll just always say it, we don't terminate apprentices at the completion of their apprenticeship and then recommence them. It is simply an ongoing period of employment. If we're offering them ongoing employment as a tradesman, it's not a termination of any kind. It's going from one position to a new position. If I was your receptionist and then I went to your accounts role, it's not a new period of employment. It's not a new employment. It's just simply taking up a new position within the same period of employment. There are often some misconceptions around the accrual of leave, and that's partly due to the way accruals have been dealt with by previous legislation. Previously, with the entitlement to, say, sick leave just became due at the start of each calendar year or the start of each employment year under previous legislation. Then in the work choices system, it was accruals happen on a 4-weekly basis. Under the Fair Work Act, accruals are progressive throughout the year. So from minute 1, hour 1, day 1, there's an entitlement to leave during that time, and it accrues from that date. So there's misconceptions from both employers and employees about that. Sometimes employees think, oh, I should be getting my 10 days of sick leave or personal/carers leave each year. Yes, you do each year. By the completion of the year, you will have accrued 10 days. There's nothing preventing them from using what leave they have accrued. So if they're 6 months into their employment and they haven't taken any sick leave and they want to use 5 days that are owing to them, they can use 5 days. They don't have to reach any period of time before they can access the leave. Previously, people had this belief that, and it was a condition previously, but not since the Fair Work Act or the work choices before that you couldn't access leave until you'd passed your probation period or perhaps 12 months or something like that. That's not the case. It's simply if you've accrued it and there's a request and it doesn't unreasonably impact on operational basis, the worker can access it. Casual employees still don't accrue paid leave conditions. Annual leave, casual employees and their entitlements is a little bit of a tricky or funny area at this time because we've had this scheme versus work pack decision where, in short, in that decision, the casuals had become entitled to leave under those circumstances. There's a range of aspects of that case that are still before the courts, so we will wait and see the impact on how we engage casuals. In short, the matter there was that Workpac had a contract of employment that was a little bit ambiguous about whether the worker was a casual or not a casual. There isn't a default definition of casual employee, and the judge found in that case that the person was an ongoing employee. Expectation of ongoing employment. It wasn't clear that they were being remunerated as a casual, those sorts of things. The federal government is looking to ensure that there isn't any double dipping type back pay implications, because if any employer who had the part the employers are largely scared of in this respect with casuals is if all casuals who've been engaged for perhaps, let's say, 6-month period or longer become entitled to annual leave from that time, that would literally bankrupt every employer who's ever used casuals in the past, particularly given that you're looking at potentially 6 years back. So it's just not it's not a situation. It's an unintended consequence of this case, and certainly while the decision may stand, the impact just couldn't be allowed to go forward. It would literally destroy employment. And even, despite the rhetoric of the ACTU, there's no possible way that can be in the interests of employees to have all employers go bankrupt and arguably sink a country based on that back pay entitlement. So they're the aspects we're waiting to see how they'll come into practice. And we could find that there is some middle ground struck there, as often there can be. Annual leave for someone who is a shift worker, and a shift worker is defined in the National Employment Standards as someone who regularly does weekends and public holiday, works weekends and public holidays, is entitled to an extra week of annual leave. Just because someone does a short period of other than continuous shift work, for instance, or maybe does a couple of months or 3 months of some shift work, including night and afternoon work, doesn't entitle them to the annual leave component. Even if someone was a shift worker more consistently than that, it's about whether or not they have regularly worked. And whilst it's not a precedent, there's a precedent that the case says you can't use this as a precedent, but that's the way cases work. There is a decision, a Roy Hill decision, that says 36 weekends in a year is the magical number, so as a guide to whether or not someone is regularly working weekends in order to entitle them to that extra week of leave, as in terms of annual leave. A relatively new provision is cashing out of annual leave in the modern awards. So there are a number of safeguards. Cashing out of annual leave provisions have been allowable in the legislation for a very long time, but they haven't been included in the award provisions until within the last 2.5 years or so. So they're a relatively new award condition. Previously, we've had to say, look, we can't do that. But now that we have the provisions in the award, we can, within these limitations, agree to cashing out of the annual leave. So there's 4 safeguards there. There needs to be, it can only be a maximum of 2 weeks, must have 4 weeks remaining after the cashing out. We need confirmation.
Welcome to CW Electrical Annette speaking.
Sorry about that. So the specific record keeping and including getting a signature from parents for minors, if that's something they want to do. Employers can't put undue influence or pressure in relation to that cashing out. And it's not that I've really seen that typically, but because it's a new provision and typically employee organisations, unions have a bit of a paternalistic view about whether or not people should or shouldn't be able to cash out annual leave, because annual leave is there for rest and recovery as much as recreation. So that there's some safeguards there to ensure that employers aren't trying to get people to take leave to keep their leave balances down and the liabilities to the business down, and that the entitlement's still there for what it's intended for. Enterprise agreements, as I say, there's been a provision, a model term in the legislation for a long time, many years now, since the Workplace Relations Act of 1996. But you've had to have had it in an agreed to in an enterprise agreement. So we've been limited to those agreements that had those provisions. It's a slightly different term to the modern award term, in that that workers can cash out as much as they like, but they must have 4 weeks remaining after the cashing out has occurred. So that's where there's an important distinction there between the legislation or allowable terms in an enterprise agreement versus the modern award condition. One of the main areas that we get questions from employers around is when can an employer direct a worker to take leave, or what do we do about workers with those excessive leave balances? Now that we have the cashing out provisions, you can see if a worker wants to cash out a period of annual leave. So if you want to reduce the balance, you can say, well, hey, if you don't want to take this, that's fine. Let's cash some of it out. So that's a possibility to reduce it if it meets those criteria there. If we're looking for someone to take leave and wanting to direct them, and what we mean by direct is force the worker to take leave. They have to have at least 2 years worth of accrual, which for a full-time worker would be 8 weeks. We have obligation under the award to consult first to reach agreement. That's a relatively new provision. Previously, it's been, you can just issue the notice, but the consultation provisions are new to the award. It still gives the ability for the employer, if there isn't the agreement, that they can direct the worker to take leave after that consultation process has been exhausted. That consultation process, though, I guess to point out, goes both ways. So if an employee is seeking to take leave, but the employer is saying, no, we're too busy, no, we're too busy, and just keeps pushing leave back, but the worker wants to take a period of leave, they can also invoke under the same criteria the desire to take, or the want to take leave and go to that same consultation process in order to reach agreement about when they can take the leave rather than the employer directing them. At other times, leave needs to be taken at a mutually agreed time. Mutually agreed is underlined or emphasised there for, I guess, a few different reasons. In that it could be the case that an employer wants people to take leave because there's slowdown of work, and that they're looking to alleviate strain on the business. So we can consult and talk about that. It's often the case that someone wants to take a long period of leave, and the employer's not keen on someone taking, say, 8 weeks of leave, but they have given the employer maybe 6 months' notice. An employer might not want to give that person leave, but the worker has given a substantial period of notice of that desire to take the leave. So while the employer does have the ability to reject applications based on operational reasons and operational requirements, there's some limitations to that. If you've been given, and that'll depend around those sorts of criteria, like how much notice have you been given, what's the period of time off, that's been requested. Those are probably your main ports of call. Oftentimes, solar companies, air conditioning businesses will say, hey, Christmas, this hot period of time, that's when things go bang, and or people are wanting to, we're going gangbusters, so they want to ensure all hands are on deck there. There's the ability to refuse applications to a point, extenuating circumstances and or a day here or there. We're going to have the same sorts of inabilities to say no carte blanche to all leave applications, because there may be occasions in which we've got no choice, because otherwise we're taking what's called adverse action against a worker by refusing. I need to take additional time off to assist recovery of someone or care for a child. Can't access sick leave to care at this time because maybe it's daycare is closed for whatever reason and they need to take an annual leave day. It would be borderline unlawful for an employer to refuse a leave application on that sort of basis. Employers also don't have the ability to direct workers to take unpaid leave. Oftentimes people look at that as stand-down provisions, and I guess Townsville in flooding recently has highlighted where and when the stand-down provisions of stand-down provisions of the legislation might be applicable, notwithstanding that the award itself, electrical award, has what are called inclement weather provisions. Employer in generally cannot simply, just because they have run low on work or unable to provide work, they can't direct a worker to take leave without pay in that scenario. They've got an obligation to pay a 38-hour week, but you can agree through either rolling periods of annual leave, and that might include periods of leave without pay by mutual agreement. And these are the sorts of things you can do during quiet times as much as anything. In quiet times, or seeking to alleviate the impacts of quiet times, consultation is your friend. There's a process attached to it. It's a conversation. There's many different ways to achieve it, but ultimately looking at consultation prior to any decision there. Personal/carers leave, everyone knows that, or everyone still calls that sick leave, but the legislation calls that personal/carers leave. In basic terms, is where the employee is not fit for work because of an illness or injury. In the carers leave component, is to provide care or support to a member of the employee's immediate family or the employee's household who requires care or support because they have a personal illness or injury, or there's an unexpected emergency affecting that member. As I indicated before, it's not for daycare type scenarios. If wife usually looks after the child, but she wants to go out with friends, and so she's saying it's your job today, honey. If that's the way the arrangement works, the worker can't say, well, I need to take personal leave in that scenario. They'd need to apply for annual leave. However, if grandma was the one who regularly would look after the child on, let's say, a Friday or something like that, and grandma was in a car accident on the way there, in my example, grandma's fine, she's just car's a bit pingled, so she can't get there. There's an unexpected emergency, and it's affecting the member of the immediate family, either grandma or the child, but we're talking about the child in this instance. So grandma isn't able to come over for the usual Friday daycare day, grandma day, or grandpa day, so the worker needs to stay home. There's an unexpected emergency there. Yes, it's still daycare type scenario, but because of that unexpected emergency element, they would be entitled to utilise that personal/carers leave in that example. I put what might seem like a joke there about the VB ad. You can get it any old how. Personal/carers leave, from an employer's perspective, there's a common bugbear that arises. Johnny, the wild apprentice, got into a fight at the pub. Someone broke his jaw. Now he needs 2 weeks off. I shouldn't have to pay for that. He was being a fool. The VB ad applies. You can get it, picking up your kids. You can get it digging into the trench. You can get it getting punched in the face at the pub. You can get it any old how. So just because it's not occurred, doing something you would otherwise do, doesn't mean that their worker isn't entitled to take that leave or claim that leave for that period if they're unfit for work. Common areas around personal carers leave and questions are around that the evidence requirements. So Section 107 of the legislation puts the notice and evidence requirements. By notice, we mean they might call up the boss or the supervisor and say, I'm unwell today, I can't come in, expect to be fine tomorrow. That's a requirement, an obligation on the worker. The employer also has the ability to request that reasonable evidence. Just a couple of things are about reasonable evidence. Reasonable evidence may be a medical certificate, but it may simply be a statutory declaration. It might be a picture of a busted toe or a swollen ankle. It might be a physio's report. It might be a pharmacist's note. It might be a psychologist's note. It might also be a full medico-legal report by a treating specialist. So reasonable evidence is how long is a piece of string is the answer there. If someone's got a sniffle and they say, boss, I've got a sniffle, it would be unreasonable to say that person has to go and get a full medical clearance before returning to work, or a full medical report about their condition in order to substantiate their sick leave claim. And that would be an unreasonable level of evidence required there. So policies might say, or employment contracts might say, or even enterprise agreements might say you need to provide medical certificates. That is not that is unenforceable if we're simply saying that's the only evidence you can supply, because legislation overrides it and it says reasonable evidence to satisfy, so we'd need to accept that as well. One of the other common questions is, someone might have had a shoulder complaint or a back complaint that simply was a general practitioner GP said, take a week off, until this settles down, just rest. Or even a physio perhaps. They take 3 days off. had their Nurophens, their Voltarens, whatever, stretched up, rolled out, whatever, and now they're ready to come back to work after 3 days. Employers might often say, "Oh no, the medical certificate said you can't. You've got a week off. I'm not having you back," or maybe even it's because of a sniffle. We need to be considered again in that approach. If someone hops out of the vehicle and they say that they're good to, or they said they're good to go from their back condition, and they hop out of the vehicle and they've got a Zimmer frame and they're not able to walk properly, well then certainly you'd say, no, you're not good to go. You're clearly still not fit for work, so we're not accepting you to return to work yet. But if the worker is otherwise able to move without restriction and or carry things without wincing or crying out in pain, there's no reason to reasonably suspect that they're still unfit for work. So we could effect a check there. We can still, well, we're not medical practitioners ourselves, we can still put this person through a bit of some paces. Okay, you want to come back early, but I want to see that you're actually fit for work. So here we go, a little bit of calisthenics. Show me that you can lift that cable thing, roll a cable. Show me that you can bend over without extreme pain, squat position, lift things above your head, and if they can't do that without, exhibiting some symptoms of a pain response, which we can all see what that means, then we can say, well, okay, you're fine to work in that. Complicated medical conditions are an absolute rabbit hole. It's a real Alice in Wonderland type scenario. We will be covering off what happens in those sorts of scenarios in more detail in the next webinar. So if you're interested in things around complicated leave, complicated illness, injury, mental health conditions, how to deal with those, long incapacities to return to work, that will be the focus of our next presentation. And this we'll go further down, but I won't go further down the rabbit hole just now. I'll save the Mad Hatter's Tea Party till then. But some myths around the accruals with respect to sick leave and personal/carers leave in particular. There's still the idea that leave balances reset after a period of time, yearly or whatever. That's not the case. There is no cap to the amount of leave that can be taken or accrued. So if a worker has been with you for 5 years, they've never taken a day as a full-time employee, never taken a day of sick leave, they are entitled to 50 days of leave. If they broke their leg and needed 50 days off, they could take 50 days. Or if they needed 30 days off, they could take the 30 days. Accruals continue to occur during any paid leave entitlements. So if I'm on sick leave, I'm still accruing annual leave and sick leave because those leave periods are considered time worked. So we need to understand that one as well. However, leave accruals usually stop during unpaid leave. I say check EBAs there because different enterprise bargaining agreements, particularly if you have perhaps one of the ETU EBA versions, they have a different definition of service to effectively get away from that someone might be on unpaid leave, but they'll continue to accrue their annual leave and sick leave during that time. But for those employers covered by the modern award and either the electrical one or the clerical one, if a worker's on unpaid leave, they stop accruing leave there. The other common bugbear is where a worker seems to take every Monday off or every Friday off, or as soon as they've accrued a full day of sick leave, they will take the day off. These workers have been around since, I guess, the accrual of paid leave or the concept of paid leave entitlements existed, and it's problematic. It's absenteeism, and different economists like to stare at the wall and create a value to that cost of business, for each country across the world. It's a problem. It's a problem also because in just about every occasion, we'll focus on Australia obviously, it's difficult for an employer to take action against a worker who is sick. It's unlawful for an employer to discipline, warn or dismiss a worker because they've taken a period of sick leave or they have a pattern of sick leave, that might look otherwise suspicious. If we don't have evidence that they're not sick, and actual evidence, then we have limited options. And evidence might be the classic, we saw you doing the Mexican wave with 40 beer plastic cup snake on the TV. We don't think there's evidence there that you're not actually sick. You're not, so therefore it's a false claim. That might be a basis to take action, but it's about the dishonesty, not about whether they took sick leave or not. And oftentimes it's difficult, and you don't get that evidence that the worker was actually sick at the time, or wasn't actually sick at the time, I should say. We can take some actions with respect to, I guess, making life a little bit more difficult for those people who like to call in sick just because they're perhaps not feeling it today, not feeling 100% motivated, rather than actually feeling 100% unwell or the like. It is a reasonable and lawful direction to direct someone to call rather than text. The owner or supervisor, not a supervising tradesman if you're an apprentice, but the actual owner or director, owner, manager, or supervisor, not their workmate. That they actually call as opposed to text. Texting is very easily, we can say all kinds of things behind the keyboard or the smartphone screen, but oftentimes it can be just a little bit harder to say it. It also gives the opportunity for the employer to reasonably ask questions around, well, is there any handover requirements with respect to jobs? Are there any, what's the likely time frame? Clarify some points. Did you contact Mrs. Jones, or who's got this testing equipment, or arrange for any materials that might need to be collected or otherwise. Are they on site or are they in the van? Just to help with some of those operational things. So yes, it might be scenarios where a worker is too unwell to participate or to phone. But in the general direction would be that there is no texting and that there should be a call. It is then appropriate, if someone doesn't follow those directions, to consider the disciplinary process and the disciplinary action. If those things, you've called in, you've texted in sick, you haven't given us any information, you haven't followed our lawful and reasonable direction, why shouldn't we give you an opportunity, a warning in relation to that? And you give them an opportunity to respond. Well, if I was in hospital because I got my lights punched out and I was unconscious, what's going to be very difficult for me to text or call, and that's why you didn't get notification from me until 12 p.m. that day, and instead of before the start time. And that's why we say where practicable. It's also a good idea to have a policy position which establishes whether you're going to require evidence after a certain period of time or not. In terms of traditionally, because the awards previously have said, after 2 consecutive days. The legislation and awards don't have that kind of provision anymore. It just simply gives the ability of the employer to request it at any time or to establish their policy position. And popular ones are, if you're having a sick day on a Monday or a public holiday, or a sick day on a Monday or a Friday or following a public holiday. Some people like to chuck in the state of origin for Queensland or major sporting events, grand finals and the like. They say, well, you've got to provide us with a medical certificate if it's occurring after that date. Is a bit of a popular one which you can do by policy, so evidence such as a medical certificate in that scenario. By default, the worker, if requested, needs to provide that reasonable evidence. So we dealt with, I guess, at the beginning a little bit around compassionate leave and what it's there for. It's 2 days per occasion in the case of serious injury, illness, or death of an member of the immediate family. The definition of immediate family is mother, father, grandmother, grandfather, brother, sister, de facto, former de facto, and the mother, father, brother, sister of and grandparents of the spouse or former de facto spouse. So it is a range, but it doesn't extend to aunts and uncles. It doesn't extend to furred, feathered, or scaled members of the household. It's simply for the humanoid versions. That's the definition of immediate family. In the case of serious injury or illness, the 2 days compassionate leave is to spend time with. It's not from any leave balance, although they might want to, if they want more time than the 2 days, they'll need to apply for some other type of leave. I highlight, or put in inverted commas there, to spend time with in the case of serious injury or illness, because I have had a strange scenario, well, I would say it was strange, where a worker wanted to take off time because their father had recently been diagnosed with terminal illness, and the worker wanted to take time off for that purpose. However, it wasn't to spend time with the worker because the worker's father was in the UK. They weren't travelling to the UK. They were just simply wanting to take some time off. I don't say the claim wasn't legitimate and that it affected them, but it just doesn't trigger that compassionate leave element because they weren't travelling to spend time with them. It's perhaps a scenario where a good example is, grandpa's had a fall. He's in hospital. Want to spend some time with him because maybe touch and go, but perhaps grandpa pulls through, or maybe he does pass away. The 2 days compassionate leave is to spend time with. And let's say perhaps grandpa does pull through, he goes home, and then in 2 weeks' time or 2 months' time, he has another fall, but is not so lucky to pull through this time. That is 2 separate occasions, tragic as it is. So that's 2 separate occasions for compassionate leave, and the worker would be entitled to those 2 days in that scenario. Even though it relates to the same person, there's clearly a distinction there, and there's 2 occasions, one being 2 months or 2 weeks apart from the other. Personal carers leave is not usually applicable unless that person is suffering from an illness or an injury, or someone in their immediate family is, following that serious injury or illness. So maybe they're the primary, they're the only child, and the father is perhaps the only person, their parent left alive. They might have a serious injury or illness, spend time with them, then they help them at home, provide care and support while they get their strength back, or recovery for some surgery, or require time off attached to that. Yeah, personal or the carer's leave component would be applicable there. But not simply because perhaps the grandfather has passed away, the 2 days have been exhausted, they're still upset, but that's the compassionate leave component has ended, and they would need to apply for some other leave, grief not being a medical condition as such. So I'll perhaps move to the other end of the circle of life in the parental leave. We're dealing with obviously scenarios where we're talking about birth, but it also extends to adoption leave. The main component is for the primary caregiver, in that's the 12 months off. That's the unpaid component, and as I indicated earlier, requests for additional periods of leave are fairly rare. You don't get those very often. Given that we're electrical contractors and there's still a fairly high quotient of men doing that trade, usually we're dealing with the situation where it's the partner wanting to take a period of leave, where their wife or girlfriend is having the baby. So that's where we deal with there. The partner can take up to 8 weeks of unpaid parental leave concurrently. Usually what happens though is that the partner takes a period of annual leave of whatever length, so that they can be paid. There is confusion around what is the 2-week government incentive and who pays for that and the like. That's called the Dad and Partner Pay scheme. It is a government scheme. It's administered by Centrelink, Department of Human Services. It's 2 weeks at the federal minimum wage, or the national minimum wage, I should say. They can't be taking annual leave or any other form of leave from their employer at the same time, or paid leave, I should say, at the same time. So they can't have annual leave and this Dad and Partner Pay. And they need to make that application to the government themselves. It's not something the employer has to do on their behalf, or does, pays out this amount and then gets it back later. It's an application the worker needs to make. The employer may be asked to administer the money, but is only required to pay the money out once they've actually received it themselves from the government. So usually, for those sorts of delay reasons, the worker, if they are accessing this scheme, just simply goes directly through the Department of Human Services, Centrelink, to get that A typical area with respect to partners in this area around parental leave and payment is the use of personal carers leave again. It's not common. Childbirth is not considered a medical condition. It's not a whole lot of fun from the lady's perspective, and certainly warrants and needs some rest and recovery following it, but it's not a medical condition, nor is it an unexpected emergency. However, there are many occasions in which many different, things that can happen following a childbirth. Maybe it's an emergency cesarean, maybe it's a planned cesarean, maybe there's an injury or illness resultant from the childbirth, that the mother might need to stay in hospital for longer, be at home but require additional care or support, as a result of the injury or illness. So there will be a period of time that they may be able to utilise the carers leave, because they're not simply spending time with the new family. They're providing more. They're providing care to someone who has an illness or an injury, perhaps resulting from a cesarean. Cesareans typically, and it seems to be still standard, that you can't drive for 6 weeks. We're not talking about 6 weeks of personal leave because they can't get out and about themselves. We're talking about whether or not someone provides support to simply do the basics of getting up and around and attending to themselves as much as anything else. So there can be situations, and a cesarean is one example, where the worker might take a period of carers leave, but we would also be within our rights to request evidence with respect to that. Now, I haven't had any questions, which must mean that I'm being incredibly thorough, or you're shy. But feel free to put some questions into that chat area, and we can cover off those sorts of scenarios. I am focusing a little bit on the areas that often cause bugbears for employers, so maybe I am answering some of those burning questions, but typically I usually get a question where there's a scenario slightly different that people want to cover off. So feel free to ask, and I'll answer away. Community service leave. Thank you, Carly. Good question. Can employees take personal leave for doctor's appointments? The good example of that is going to the dentist. I'm going to the dentist simply to have my teeth cleaned and have a checkup. That is annual leave. Versus I'm going to the dentist to have a root canal, or to have a filling, or to have some sort of treatment. That is personal leave. So if someone's simply going to the doctors for their regular checkup, or maybe even a vaccination, that would be an annual leave, or take an RDO, or maybe make arrangements to work a shorter day or a longer day or something like that. But if they're seeking or receiving some treatment at that appointment, then personal carers leave would be appropriate in that scenario. It can be a fine line. It can be difficult to determine that in certain cases. If we know someone's got a condition and they may or may not be receiving treatment at that appointment, then we might simply take the conservative approach to say, well, okay, this is going to be personal leave. But if someone's simply going along to get a test done and or follow up for those test results, then we wouldn't say that there's a fitness for duty question there. A question as well in relation to parental leave. I'd like to be able to pay a worker without it being part of their annual leave. Yeah, there's absolutely nothing wrong with or preventing you or prohibiting you in any way from paying leave over and above as a parental leave scheme. Oftentimes businesses will have a policy to establish that. And it's becoming, I guess, more common, particularly depending on the size of the business. The larger the business, the more likely they are to have something like a paid parental leave scheme of their own initiative on top of the federal government amount. You could have it as much as you like or as little as you like. Best to have a policy position if you have a larger workforce, so that you can remain consistent and that it can be managed appropriately. It could be in their employment agreement. I mean, you could make it individual. Maybe you've got a position in particular that's hard to recruit for, or you want to keep someone who you value highly, and you believe, or you're aware that they're looking to take some parental leave, and you don't want them to, give up give up the employment game with you. So you might write in there that you're offering this some sort of incentive to keep them around and keep them happy. Those sorts of things, absolutely fine to do that by the policy or an employment agreement. Yep, that's a good question, Amanda. Thanks. So community service leave has more broad banner these days as an entitlement than previous. Previously, it was just simply jury duty. Was all that the leave was for, jury duty leave. There's also the coverage now of voluntary emergency management activities, SES, looking for Sally, or who's lost in the bush, or recovery efforts in terms of natural disasters, those sorts of things. That's where we're looking at voluntary emergency management activities. A worker needs to provide evidence to support that they are part of and have been involved in such an activity. So it's reasonable to expect that evidence. That voluntary emergency management activities, that is an unpaid component. The jury duty component is still paid. However, it has actually come down from being uncapped under the Work Choices and Work-Based Relations legislation to now under the Fair Work Act of 10 years to being capped at 10 days. The payment is less the court payment, so you might find that the worker gets $40 or $50 a day from the court, maybe even less, that they are only required to have their wage topped up to their normal wage. It is possible for employers to request that excusal from jury service. As usual, we have a template for that letter if you ever get into that scenario. Its duty is not from any leave entitlement. I'm sorry to say. It's just it's again a payment required by the business to be made, and yes, it can be a cost that we're expected to bear as employers. What is also possible with the jury duty and selection is that a worker may get called up. They go in for the first day. They don't get impanelled on any jury, and they return to work halfway through the day or the following day, depending on how long it took them to go through that impanelling process. They usually have to go a second week, because it's usually 2 weeks that they've called for at a time, and in that second week, the same scenario might occur on the Monday that they aren't impaneled. So in that scenario, the worker would only be entitled for a single day. They don't get to say, well, I'm on jury duty, so I'm taking 10 days off. They actually need to be either impaneled or waiting to be impaneled for that payment to be made. It's not if they've been released and said they're free to go. Well, that by default means free to return to work, and in the case of someone employed, and continue to work. They don't get to just sit at home for 10 days and get paid the top-up pay, because the court will only pay them for the days in which they are there. Long service leave. Long service leave is still a state-based provision, so the legislation is covered by each state. It's not dealt with by the Fair Work Act. While there are some minor differences between the states, the general condition is that 8.667 weeks for 10 years of service. Some people may have enterprise agreements, perhaps, which provide for a higher standard. It's not very common, but they may exist. By default, the legislation is that 8.667 weeks after 10 years of service. Just had a quick question there on the jury duty and the payment. You can request the question is, do they get a copy of the payment? You can request a copy of their remittance. They get a remittance and stub. They keep the check themselves, but they'll get a remittance slip with that. You can request a copy of that from the employer, yes, to confirm the correct payment. just on the back to the long service leave. There are pro rata entitlements in certain conditions. So typically, and I say typically because not all states have it this way, but the pro rata entitlement to pay out is after 7 years. Some have it after 5 years. So we would need to check on your circumstances if it's something that's going to apply to you. The conditions are fairly consistent in that it is if the worker is made redundant, if the worker is found to have been unfairly dismissed, if the worker dies, it's paid out to their estate, or if the worker leaves their employment for pressing or domestic necessity, which means perhaps they had to move interstate to follow their partner in their career or their job, or they're going to move to another side of town to help their parents more closely. They need to leave that job. That's a common, or even perhaps they're experiencing some personal medical condition. That would be a pressing necessity. That would mean that they need to leave their employment or should leave their employment. That doesn't mean employment in general, but just perhaps that job. Then they would be entitled to that pro rata payout in those sorts of scenarios. So that's something to watch out for. They're not entitled to take pro rata leave as a paid leave entitlement. It's simply payout on termination in those sorts of conditions. It's common to, if it's not uncommon, I should say, where a worker leaves their employment after, say, 7 years, and then they just expect their employer to pay out the long service leave without giving them any indication. So employers often will get their back up. They say, well, I'm not paying you out. Why should I pay that out? And then they'll, provide them with the rest of the story, which might mean that they then, whilst they're now annoyed because they haven't been given the fullest information, it is the case that they are entitled to that payout. So it can be a little bit it can be a little bit difficult there, but just need to make sure we ask the questions if there looks like there's an entitlement to that pro rata payout, so we can start to investigate that entitlement payout. There are portable long service leave schemes that cover the vast majority of people working in trades. As I say, there's a very, very broad definition of construction industry. South Australia, for instance, has some exemptions based on the type of work you might be doing. But for instance, Queensland, New South Wales, and the like, they have very, very broad definitions there. So even though someone might be working domestic, for instance, in Queensland, someone might be working just domestically on installations, they would still be covered. Apprentices are still covered. Queensland, the scheme's called Q Leave. New South Wales has a scheme. I can't remember the name off the top of my head. Sorry. Victoria has Co-Invest. My Leave is WA. There's schemes there. There's also schemes based on some certain industry areas, such as black coal. Black coal has its own long service leave industry scheme. Some of those schemes simply require the reporting of workers' times. For instance, Q Leave and New South Wales schemes, it's just simply reported. The clients in the construction industry, developers, they're the ones who pay in and fund the long service leave scheme, so that the employer themselves isn't paying out. New South Wales is a little bit interesting in that it only pays out up to the value of the award or the agreement EBA amount. It won't pay out the common law, or if you're paying, say, $35 an hour and the award rate is 24, they will pay out 24. The employer is responsible to pay for the balance if there's an over-award payment being made there. Queensland has a cap up to $50. Most of the other states, the other states require a levy paid into there and into the fund scheme, and then it will pay out. I'm not sure the caps specifically, but they are there. Sorry, one last point on that long service leave before we leave it. There is some scenarios where someone is going to be covered by the scheme for a period of their service. So maybe they were a tradesman for 7 years, and then for 3 years they go into, say, a supervisor role. Well, for the supervisor period, they're not going to be covered by the scheme if they're off the tools. But for the tradesman period, let's say 7 years, they are covered by the scheme. So the employer can seek reimbursement for payout if they're paying out or leave taken for the period that they were a tradesman. and then they fund the remaining 3 years themselves. So following on from that, if a worker is a clerical or administration worker and they've been with you for 10 years, the employer is wholly responsible for funding that long service leave payment. The other tricky part often arises where there's transfer of business. You've either taken on an employee or you're going to be passing on employees as a result of a transfer of business. We can't offset, we can't buy out this long service leave entitlement. So if you're taking on a worker, you want through purchase of a business, you want to make sure that there's some allowance set aside, particularly if they're a long-serving employee and therefore likely to become entitled to it. You want to ensure that there's some consideration set up in a trust or the like for that entitlement. Should it fall due for you? Vice versa, you can't expect you can't pay it out to the worker and say, well, that's us done. It's them taking someone on. A question from Amanda: if someone has a portal long service leave account, but they don't qualify as being in the construction industry, the question, well, I guess there's a potential for a few answers to the question. If the company isn't within the definition of the construction industry, then the portable long service leave scheme entitlement will simply sit there for the worker, but the employer is expected to fund any long service leave entitlement that might end up being due to that worker, but that would only be due after the 10 years of service. If the person's been in the industry for 10 years, though, they may be able to access their portable long service leave amount and therefore request a period of time off, not as long service leave for the company, but simply a period of long service leave, so that happens. But if you're not in the construction industry, you're not required to pay into the scheme or report into the scheme if you're not. I would very much check that definition of construction industry just to confirm that you're not in it. That being not being in it is the correct approach. As I say, it's a very broad definition, and as the slide indicates, it is mandatory. And if you're in Queensland or New South Wales in particular, it's in your best interest to do so because it costs you nothing. It offsets the cost. In those other states, the levy is much less than funding the amount yourself over the period. Does long service leave apply to all sides of business? Yes. There's no exemption. Casual employees are entitled to long service leave since about 1992, consistently across the country. Each state made their own provision changes. Dana has an example of a worker, or a question around what's the minimum number of years when they have to pay out the employee a pro rata amount. Dana, I think you're in Queensland from memory, so it's a 7-year, and largely, by and large, it's a 7-year. It's a 7-year entitlement. So the pro rata is paid out after 7 years, and that's where those certain conditions apply. Where we're looking at, pressing domestic necessity, death, redundancy, unfair dismissal, those sorts of things. The most common reason for pro rata payout of long service leave is that pressing domestic necessity. If a worker simply leaves after 7 years because they found a better job, or they just don't want to work anymore in that industry, or just that job, that employer, that doesn't trigger the entitlement to the paying out. It has to be in those certain conditions, although it's often not hard for someone to get perhaps a medical report that says this person is now experiencing stress in this role and should leave it for the benefit of their health. Yeah, there you go. There you got pressing a domestic necessity, and they should have the entitlement paid out to them. So that can be problematic. So family domestic violence leave. It's a new one. It was originally last year just inserted into the awards as a new award entitlement to a period of unpaid leave, as it says there, 5 days unpaid. It just simply is due from the day they start work. It's not accrued. Is renewed every 12 months. Doesn't accumulate from year to year. And later on in the year last year, it went from being just an award entitlement to being part of the national employment standards. So it's a new national employment standard. So we now, instead of having 10, we have 11 national employment standards. And so regardless of whether someone's covered by the award or an older agreement, from that date of the 12th of December 2018, they're entitled to that. There are some provisions within the award around how people go about accessing that leave. And requirements on the employer with respect to consultation, with respect to confidentiality of information, when and where it's appropriate to pass it on. But effectively, it's a new entitlement to unpaid leave. From our perspective, it's not a particularly controversial addition. I think I've found in the past most employers that have employees in these sorts of circumstances are accommodating in any event, but it is helpful to have some parameters in there for us to understand what is or isn't within this scope. It's been made clear by this definition that it's intended for victims only, not if you're an alleged perpetrator. You're not able to make this claim. But there's potential for some, difficulties in that space. If someone's using a domestic violence allegation as a weapon in itself, how is that dealt with by this leave entitlement? That's very, very difficult. And an employer, our position has been an employer is going to be very hard pressed if they're in a position of having to form quasi-legal opinions about whether someone is or isn't a victim. So perhaps they're going to take, the conservative approach and simply give it to a worker who might otherwise not be entitled to it. But there's still some early days with this area of a leave entitlement, and I guess the nature of employment is we probably will find some disputes and precedent decisions as the years go on. But it would be interesting to see how it applies in those sorts of cases where someone is alleging that the claims made against them have been done so in an inappropriate way. So that's the family and domestic violence leave. That's our newest provision. We have done some articles on that topic that you might have seen, or it's certainly available to view in the award. The award condition now is exactly the same as the legislation condition. They haven't made any differences there, which is great because we don't want to see too many inconsistencies between awards and legislation. It makes it confusing for us. So they've made that pretty straightforward. I guess from my perspective, it's always been fairly rare that family domestic violence situations or leave situations have occurred. Obviously, they do occur. It's just not something I've, from an professional employment advising perspective, have come across a great deal. As I say, because I think a lot of times businesses are simply dealing with those sorts of things as they come and affording the people the support and flexibility they might otherwise require. But we now have some specific provisions in the legislation. So that's all from me today. I think I managed to keep it pretty much to the hour mark, which is the intention, to be fairly short and sweet and not keep you too long. Thanks for coming along. Those people who were able to join us. I'll have another question on compassionate leave from Dana. The question there about per occasion is effectively what we're looking at there. That would be, in the example that you give there, that would be two separate occasions. If they passed away later after receiving the diagnosis, they received the diagnosis, they spent time with them, then they pass away some time later, that would be two separate occasions. It's not simply linked to a person. It's someone. It could be two occasions. Maybe someone has a particularly unlucky period, and they get hit by a car, they recover. Maybe they get hit by another car. They're all classified as serious illnesses or injuries. Or they have complications, relating from in that recovery. That there could be multiple occasions that entitle a person to compassionate leave, because it meets that definition of serious injury or illness. And when we mean serious injury or illness, we're looking at whether the death, I guess, frankly, is a likely outcome of what's occurred, either as an accident or as an illness, cancer, perhaps a diagnosis. That can be a trigger to entitle the worker to the compassionate leave. So next up, we will have, I guess, a little bit more on the leave area, but we'll focus mostly on long-term injury, illness, or as well complicated illness and injury. We're looking at responses and approaches to workers as part of that with mental health conditions, as an example of complicated or long-term illness or injuries. We'll be looking fairly closely at the approach an employer can take with respect to determining a worker's capacity, talk about things around reasonable adjustments, how we might go about getting medico-legal reports, those sorts of things. Oops, sorry. In what questions we might ask of a doctor, and determining who an appropriate doctor is to consider certain types of conditions. So as I mentioned earlier, it can get very Alice in Wonderland in this scenario, in these complicated illness and injuries. We don't necessarily know which way they're going to go. We might have ideas about someone's prospects or likelihood of returning to work, but ultimately we're not suitably qualified medical practitioners. So we need to rely on that advice, and I guess we're largely talking about getting that advice and how we can proceed from there, and what our options might look like, including termination for permanent incapacity, to be able to perform their inherent requirements of their role. So hopefully you can join us on that one next month, next month, and we can continue on our topics of leave. Thanks for joining us today, taking the time out. If you have any questions, by all means, shoot us an email, give us a call. If you have any other types of questions on leave or even the next topic, you got a scenario that you want to get ahead of and didn't realize we might be able to help you with that, by all means, shoot us an email or give us a call. We can talk to you further. So thanks everyone for coming along.